Hi, my name is Chris Yukins. I'm the Lynn David Research Professor of Government Procurement Law at George Washington University Law School in Washington, D.C., in the Government Procurement Law program there. I've been asked to present this short presentation on what makes an effective bid protest challenge system. It's asked by the organizers of the Indo-Pacific Economic Framework for Prosperity, Pillar 4 workshop on public procurement held in Kuala Lumpur on the 9th and 10th of October. I can't be there on the 10th of October, so after my live presentation on the 9th, I've prepared this for presentation on the 10th. Thank you very much. I have to fly back to Washington. Thank you for your patience. The focus of the workshop has been on how to implement Article 9 of the UN Convention Against Corruption, which is noticed has been adopted by most nations around the world, almost all nations around the world. And Article 9 calls for, among other things, an effective system of domestic review. Specifically, it calls for an effective system of domestic review, including an effective system of appeal to ensure legal recourse and remedies in the event that rules or procedures established pursuant to this paragraph are not followed. One thing to highlight here is that besides calling for an effective system, and the rest of the presentation will be how we measure what an effective system is, it contemplates an effective system of appeal as well. And that means that you would have both a bid challenge potentially in, say, the agency itself or an independent agency, but you also have an effective system of appeal. So not just one level of review, but a higher level of appeal as well. And that's an important part of figuring out how we would structure an effective system of domestic review. And I will be talking about that over the subsequent slides. Now, when we're talking about system of a domestic review, we should point out that this is really the same word that's used in different ways around the world for the same system. In the United States, we call them bid protests. If a bidder is disappointed with the outcome of a procurement, or if a bidder wants to challenge the terms of a solicitation, they bring a bid protest. In the United States, UNCAC refers to it as a domestic review system. In the European Union, there are remedies directives that govern these bid challenges. They're called remedies proceedings there. And then under the UNCITRAL model law, the UN Commission on International Trade Law model law, they're referred to as challenge proceedings. Now, before reviewing what makes an effective bid challenge system, we should talk about what the purposes are, what the goals are here of a bid challenge system. This is something that we reviewed in a report that we did in response to a request from Congress. The National Defense Authorization Act included a request for a study on Defense Department bid protests, and we did the study through the Acquisition Innovation Research Center. It's available online, and the study cites extensive literature, especially in the American system, for trying to figure out what the purposes are of a bid protest system or a bid challenge system. And really it comes down to, this is based on extensive review of the literature, extensive interviews, the work I did on the UNCITRAL model law, for example. So all of them came together here, and really we try to define two different purposes for bid challenges. The first purpose, which is broadly recognized around the world, is to address the complaints of a disappointed bidder so that the bidder will return for future competitions. It's a way of maintaining effective competitive markets in public procurement by making sure that bidders, as they enter the marketplace, are confident that the rules will be complied with. The second purpose, which is just beginning to be understood around the world, is understanding that the bid challenges serve as part of a risk management system. They're really an early warning system in risk management. They're an early warning that something has gone wrong with the procurement system. And in that process, the challenger, the bid protester, is in effect a whistleblower. And once you recognize that the bid challenger isn't just an annoyance, but in fact is an important part of making sure that the system works effectively, how we treat that challenger changes. The challenger becomes a cherished part of the system because he is the best way of identifying where there are problems that need to be rectified in future procurements. Now, I just want to review here what are the major issues or elements of a bid challenge system. And this is based on an article done by a colleague of ours, Dan Gordon. He was for a time the associate dean of our program. He was also the lead of the bid protest function at the Government Accountability Office, our Comptroller General. He was also the acting general counsel at GAO, the Government Accountability Office. And then in the Obama administration, he was the head of the entire federal procurement system. He was the administrator of the Office of Federal Procurement Policy. So very experienced person. And Dan is an extraordinarily good thinker and good writer. And he wrote this article that was published in the Public Contract Law Journal, Constructing a Bid Protest Process, Choices Every Procurement Challenge System Must Make, laying out what are the basic elements. And we return to this again and again as we analyze bid challenge systems. So the first question that Dan posed is, who may protest? And this question, it seems pretty simple, but it really isn't. You think, well, it's going to be a bidder or a prospective bidder. That's obvious, right? That's who an interested party is. That may change over time. As there's more and more open contracting, more and more open procurement, we may want to, and for example, some states in the United States already do this, that we allow broader standing. We allow more parties to bring challenges because more and more parties have access, really effective access to more procurement information. So this question of who can be a whistleblower, who can be a protester, may change over time as there's more transparency to the system. The next question is where the protest could be heard. And as I alluded to before, there's typically, for instance, on the UN model procurement law, typically 3 different fora that could be used. One would be bringing a protest to the agency itself, and that's occurred, I'm sure, for thousands of years. For as long as there's been public procurement, we know that there was, for example, public procurement of the Roman Empire, that anytime a bidder was upset with the outcome, of course, if there was a complaint to the let's say the public body running a procurement in ancient Rome, that would be an agency level protest. So that's one option. The second option is to have an independent agency. That's one of the options we have in the U.S. system. The GAO, the Government Accountability Office, where Dan Gordon worked, that's an independent agency. And the third is to have court review. That type of judicial review, however, tends to be relatively slow, and so it's less popular as a resort, but it's almost always included. So many countries have all 3. And again, the UN model procurement law contemplates having all 3. The next is what may be protested, or what kind of actions can be protested. The UN model procurement law, for example, for many years excluded important parts of the procurement process from review, but over time, with the revision of that model procurement law and republication in 2011, a lot more was opened up to protest. So this question, what can be protested, can expand and contract over time. The next question is whether or not contracts should be final. In some systems, for example, in the European Union, some member states, once a contract is signed, it can't be reopened. So you have to create an artificial means of holding open the contract, not allowing it to be signed until the bid challenge process can be completed. Next is the time limits. How much time should be allowed for someone to bring a bid challenge? We talked about during the conference whether or not it should be 7 days or 10 days. It really varies. The related question is, how long should the protest itself take? Should the challenge itself take? Should it take 45 days, 100 days? Should it be indefinite? These questions are closely related to making sure that the bid challenge doesn't completely disrupt the procurement. These are why the time issues become so important, because we want to limit the impact of the bid challenge on the ongoing procurement process. Relatedly, we want to ask whether or not the procurement should be stopped during the course of the procurement. We want to ask whether or not the bid protest, the bid challenge, is abusive or inappropriate. Sometimes bid challengers may bring a bid challenge if they're the incumbent simply to extend the old contract. And some may argue that that would be inappropriate. So that's one of the open questions in a bid challenge system. What constitutes an abusive or inappropriate bid challenge? Next question is what evidence would be allowed, what administrative record would be allowed. This is a very important question because the administrative record is the support for an argument that was a reasoned decision making. So the administrative record is a critical part, and the evidence is critical to make this a legitimate process. What winning percentage there is? This is kind of an interesting question because you think, well, a court or a board or somebody reviewing a legal issue shouldn't be really concerned about how many cases win. The reality is, certainly our national experience was when you have a bid challenge, we've had this. When a bid challenge forum has too high a success rate for bid protests, it creates a downward spiral because more and more bidders will bring bid challenges knowing they have a decent chance of success, and essentially the whole system begins to come apart because there are too many bid challenges. So winning percentage is important because it informs the decision by future bidders as to whether or not, if they're disappointed, whether or not they want to bring a bid challenge. The last question is the power to enforce. Will the deciding forum have the power through an injunction or otherwise to enforce its decision? So now that we've reviewed the purpose of a bid challenge system and reviewed some of its basic elements, let's try to look at a means of assessing its effectiveness. And to make sense of this, you really need to have those first two pieces in place. What we're going to be looking at is the methodology for assessing procurement systems, so the MAP system. This was put together by the Organization for Economic Cooperation and Development based in Paris, and it reflects an international effort of experts around the world putting together this methodology. The methodology has its own secretariat now, housed within the OECD in Paris. And the MAPS, this methodology is used by the World Bank, by countries around the world to assess procurement systems. It really is the gold standard for assessing effective procurement systems in general, and also includes a component for assessing bid challenge systems. So when MAPS reviewers look at a procurement system, they're looking at the bid review or the bid challenge, the bid protest system. And these are some of the things they'll be looking at in the legal framework of the bid challenge system within the broader procurement system. And what you see here is things that really become markers for an effective bid challenge system, that participants have the right to challenge decisions or actions. That's an important part of an effective procurement system because for the reasons we talked about, the challengers should, if they feel they've been mistreated, have an opportunity to challenge. Calls for an administrative review by another body outside of the procuring agency, independent of the procuring entity, to assess the bid challenge. There should also be a right of judicial review. The rules of this bid review or bid challenge procedures should establish the matters that are subject to review so that there's what we call subject matter jurisdiction is set up. The rules will establish the time frames within, remember we talked about the need to do bid protests in a reasonably short period of time so we don't disrupt the procurement. The institution in charge of the review and the independent appeals body should be issuing decisions. So what's contemplated here is a formal issuance of decisions so we can see whether or not there's been reasoned decision making. The decisions have to be published in easily accessible places. So this is both to ensure accountability of the review process, and also this is important so that the decisions that are being issued can help fill gaps in the law. In effect, the bid challenge process with these published decisions helps fill gaps in the law. There have to be protections in place, such as protecting sensitive information. For instance, if it's classified information that's reviewed in the bid challenge process, that has to be protected. And the decisions by the independent appeals body should also be subject to a higher level appeal, such as a review by a judicial body. What we talked about before was what the legal framework should look like. In Pillar 4 of MAP, so the methodology, we're actually looking at the mechanism itself. So the reviewers would come to the country, and at the country's request, or let's say the request of Multilateral Development Bank, will actually look at the process, and they're looking to see whether or not the decisions are rendered on the basis of available evidence. So again, this very important concept of administrative law, that you're having administrative administrative decisions based on an administrative record. And you should be able to link between the two in order to ensure that there's no corruption in the process, that the appeals process, the review process itself is not corrupt, because we can say, oh, look, this decision is traceable to this piece of the administrative record. That the review of the evidence is carried out by the entity that's specified. So what you have here is clear contemplation that the body won't act willy-nilly. It's going to be reviewing the evidence and making a reasoned decision. The body or the authority in charge of reviewing the decisions of the first review body, so this is the second body that makes the review, is making final enforceable decisions. In some systems, for example, there's a requirement for first review by the contracting agency and then a subsequent review by an independent agency, which here would create final and enforceable decisions. And again, there's a reference here in paragraph D to the timeframes. And again, it's very explicit here that those timeframes should not unduly delay the procurement process or make an appeal unrealistic. Sometimes in a disaster situation, in a worst case situation, you'll see a bid protest or bid challenge that may linger for years. That's unacceptable, because that means that any decision can't have any relevance to an ongoing procurement. If the procurement's been suspended for years, then that's a disaster for the procurement process. So the goal here is to have bid challenges reviewed in a reasonable time so that the procurement can proceed if necessary. So again, thank you for your patience. I hope this has been a useful review of what makes an effective bid challenge system. If you have any questions, please feel free to send me an email. Thanks again. Bye-bye.